King Court blow. Rangers owner Dave King ordered by judge to make £11 million offer for remaining shares in club. Rangers owner Dave King has been ordered by a judge to make £11 million offer for the remaining shares in the club. The Ibrox chief was taken to court after being ordered by the Takeover Appeal Board, TAB, to make the offer for the rest of the shares in Rangers by a set deadline in April of this year. But having failed to adhere to their judgment to buy the remaining shares at a price of 20p each, the financial watchdog launched legal proceedings against King. He was found to have been in breach of financial rules during the takeover of Rangers in 2015. Advocate James McNeill QC previously told Lord Bannatyne that the panel on takeovers and mergers believes the Ibrox boss hasn't complied with the law. The lawyer told the judge how the 2006 Companies Act dictates that entrepreneurs who hold a 30% stake in businesses are compelled to make and offer to buy remaining shares. Lord Bannatyne ruled on Friday that the GERS boss now needs to offer investors 20p per share for the share capital not already controlled by him and 3 other businessmen. The financial watchdog took King to court because it believed Mr. King didn't comply with the terms of the 2006 Companies Act. Investigators acting for the panel concluded that Mr. King acted in concert with the so-called Three Bears businessmen George Lytham, George Taylor and Douglas Park to acquire the shares. The quartet acquired more than 30% of voting rights in Rangers in late 2014. The money to buy the shares came from offshore trusts which were in the name of Mr. King's family. Lawyers acting for King said he didn't have the money needed, describing him as penniless to buy back shares at 20p per voting right. Mr. King's legal team also argued that the shares were acquired by cash from his family's trusts. The businessman claimed he didn't have direct control over these trusts. Lord Bannatyne said in a written judgment today that he agreed with the submissions made to him by James McNeill QC, the advocate who acted for the takeover panel. The judge ruled that King had control over his family trusts and therefore had the cash to make the offer, saying, "Having regard to all of the relevant circumstances, in exercise of my discretion, I grant the order sought." Mr. McNeill argued that the Ibrox chief acted in concert with the Three Bears and an email showed that King knew he would have to make a share offer. In the email, Mr. Lytham wrote, "Dave, just a reminder that after we buy Lacey today, we will hold 19. We really only want to buy Artemis 10% if the intention to stay under 30%, otherwise we will have to make a mandatory offer." Lord Bannatyne's judgment went on. As Mr. McNeill pointed out, on 2 occasions the trusts have been willing to provide money for the purchase of Rangers shares when he wished them to do so. Now suddenly, when the respondent does not wish to comply with the terms of Rule 9, the trusts no longer are willing to provide any money. This tends, as Mr. McNeill submitted, to show actual de facto control over the trusts by the respondent rather than the opposite. I believe that Mr. McNeill is correct in his submission that the respondent has de facto control over the trusts. I do not accept on the information before me that because the respondent's assets have been placed within these trusts, he has no de facto control over these trusts and therefore is impecunious and cannot therefore make an order as required by Rule 9.